When setting up a new company, a lot of times the owners want to put restrictions and have certain rights with respect to the transfer of the shares. For example, if you and Joe decided to do business together, what happens if Joe decides to leave the company? Do you have the right to buy his shares back? Or if he gets divorced, or if he dies, do you want to be doing business with the ex-wife or the kids? And Joe certainly wants to make sure that his estate perhaps has the right to be bought out so that his heirs can realize the benefit of the company if they so choose. Similarly, what happens if one owner wants to sell shares in the company to a third party? Can he or she do that, or do the other owners have perhaps a first right to buy those shares back at the same price? Similarly, if one owner is authorized to sell to somebody else, do the other owners have a right to sell their shares to someone? These kinds of rights are called tag-along and drag-along rights. It's important to set forth not only specifically when you have the right to do these kinds of things, but also to set forth the procedures for how they're going to be accomplished. How are shares going to be valued? Under what payment provisions will the payments be made? Do you have to pay it all up front, or can you pay some down now and pay some over time? And will the shares be security for those obligations, or will it be unsecured? Who's got the right to buy and when? Do you have a right to make transfers, for example, to your family trust or to your children without giving the other side right to buy those shares? All those kinds of things can be set forth, and commonly are set forth in the governing documents or the shareholders' agreements governing those companies. The important thing is we can customize those to suit the needs of the individual owners.